Discrimination. Hey, unfortunately we know it exists. It exists in the form of sexual discrimination, racial discrimination, and includes age discrimination. But if that is alleged in a court of law, what is necessary to prove that it exists? Because there are plenty of laws that prevent discrimination. Well, it takes us to this week's case. It involves a real man, Otis Daniel, living in New York, and Otis was employed by basically a security company. And he was a safety director, and there he was subjected, in his opinion, and based upon his evidence, to a hostile work environment that included racial discrimination. Now, he was a man of African descent. He also happened to be gay. And working in his position, he said he was subjected to various comments, taunts, slurs that were basically intended to discriminate against him, and certainly showed a hostile work environment. Now, in cases of this nature, there's a lot of he said, she said kind of testimony, but the one thing he was able to show is that there was one specific incident in which that notorious N-word was used. And he contended that this demonstrated the possibility, and certainly in his opinion, the existence of a hostile work environment. His employer took an entirely different view. They said, no, 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 there's not any actual discrimination that's taking place here, and we don't think that this one instance is sufficient to show the existence of a hostile workplace. So they brought a motion for summary judgment. Now, under a motion for summary judgment, one party says, we don't think the evidence as it exists and as it is agreed to supports the claim being brought by, in this instance, the plaintiff. And so they brought that motion, asked the judge to decide the case then and there based upon the evidence. And the judge looked at this and he said, well, we've got evidence, clear evidence of one notorious racial slur, but that's it, and I don't find this is enough to prove the existence of a hostile work environment. So Otis wasn't pleased with this, and Otis Daniel appealed the case, and it went up to the Second District Court of Appeals, and there the court heard the same arguments, heard the same evidence. But there the court reached an entirely different decision, and the different decision basically was that, yes, we have one instance of a notorious use of a racial slur here, but what we find is that that raises the possibility of there being a hostile work environment, and accordingly we find that Otis can go forward on his case because he has at least demonstrated the possibility of there being a hostile work environment. So the case was allowed to go forward. So what do we learn from this? We learn from this a very important thing, and what we learn from this is that in the law today in the United States, the law is very sensitized to the use of racial slurs, and that in the workplace you need to be very, very careful of the terminology that you use, the conduct you engage in, because if it raises the possibility of any form of discrimination, if it raises the possibility of a hostile work environment, someone who has been allegedly discriminated against will be able to move forward on that case. Hey, we bring you cases every week so you understand how the law works. I'm David Allen.